Thank you, Mr. Assistant Deputy President. I rise to contribute to debate on the Children Criminal Proceedings and Young Offenders Legislation Amendment Bill 2025 in my capacity as Shadow Minister for Youth Justice. I do so conscious of the very real youth crime pressures being felt across our state, particularly in regional towns like Moree, Kempsey, Burke, Armidale, Tamworth, Gunnedah and so many others. I acknowledge the work of my National Party colleagues who live this daily and who advocate for their communities with sincerity and urgency. Our regional communities are hurting and their calls for safety and accountability must be heard. At the same time, we must ensure that the tools we put into law are effective, fair and grounded and in what actually works to reduce reoffending or offending. And on this point, the bill, particularly Section 5, gives me deep concern. Mr. Assistant Deputy, let me begin by recognising what the bill gets right. The reforms to the Young Offenders Act are constructive, modern and welcome, expanding access to cautions, conferences and diversion, introducing an expiry period for cautions, broadening the range of offences eligible for diversion. These changes will help reduce unnecessary court involvement and will support police and youth justice officers to intervene earlier and more effectively. For regional communities where services are stretched and early intervention is often the missing piece, these reforms are not just administrative, they are meaningful. I support these parts of the bill wholeheartedly and thank the reviewers for their work. However, the amendments to Section 5, the codification of Dolly Incapax, take us into much more difficult territory. The bill claims to reflect the common law, but the government's own second reading speech makes clear that Section 5(7) permits the presumption to be rebutted. Without evidence of a child's intellectual or moral development, and even despite evidence that a child may not have understood that their actions were seriously wrong. This is not merely codification, it is a substantial shift that lowers the evidentiary protections deliberately built into the common law. It also places very young children, overwhelmingly children with disability, trauma histories or unstable home lives at far greater risk of criminalisation. As the former National Children's Commissioner Anne Hollands has emphasised repeatedly, the 10 to 13-year-olds who come before the criminal justice system are not children with stable lives and full cognitive capacity. They are children who have endured multiple adverse experiences, violence, neglect, homelessness, cognitive impairment, school disengagement, and they are disproportionately Aboriginal children. Criminalising these children earlier does not make communities safer. It leads to higher recidivism, deeper system involvement, and worse long-term outcomes for families and communities. The evidence is consistent nationwide. Early criminalisation entrenches harm. And I'm aware that the opposition or the coalition will be moving amendments adopting a Queensland-style threshold, and I respect my colleagues' intent. They are responding to communities that want stronger tools, to address serious behaviour, and they are doing so with absolute sincerity and with real pressure on the ground. But from a youth justice perspective, it is important to put the facts on record. Queensland's test, requiring only that a child ought not to have done the act, is far lower than the New South Wales common law standard. It has been criticised for decades by child development experts and legal practitioners, and Queensland continues to face significant youth crime challenges today. So while I absolutely support my colleagues in seeking solutions for regional communities, I remain cautious about adopting a model that lowers the developmental threshold and risks sweeping more vulnerable children into the justice system. If we truly want early intervention, we must ensure that our laws do not substitute accountability for criminalisation. As someone from the regions myself, I want to say this clearly. Our communities need solutions that work. They need the tools to interrupt cycles of harm, not simply respond to them once the harm is entrenched. They need early mental health support, family assistance, culturally grounded programs, drug and alcohol services, and opportunities for young people to be diverted before offending escalates. We will not achieve that if we bring more 10 to 11 and 12-year-olds into the courts. That is why the establishment of the Youth Justice Select Committee is so important. It gives this Parliament, across parties, a chance to consider the evidence, the case law, the regional experiences, the Aboriginal overrepresentation, the developmental science, and what actually works for safer communities. This work is essential because the debate today is not just about a legal test, it is about the kind of youth justice system we want to build in New South Wales. Mr. Assistant Deputy President, I support the diversionary reforms in this bill, but I remain deeply concerned about Section 5(7) in its current form and the real risk that it will increase, not reduce, the number of vulnerable young children entering the criminal justice system. I also acknowledge and respect my colleagues' amendments, but I urge this House to consider the evidence carefully and ensure that any model we adopt strengthens community safety and honours children's rights, their developmental realities and the long-term well-being of our regions. Because to keep communities safe, we must intervene early, not simply criminalise early. Thank you.